All right, I think we have everybody. Why don't we start with the defendant's objections to the summary judgment? Can we do that?
We can certainly, Your Honor. I do have a preliminary matter, which I believe is the matter of Judge or lawyer, depending on the situation, Levinson's retention in this case, seeing as how he was the judge that signed the dispossessory order that consolidated the dispossessory action into this case. The judicial canon is clear. He cannot appear. He has declined to withdraw. He has indicated they're completely different cases. However, all you have to do is actually look at the order that he signed that says that that case was consolidated into this case. It could not be more clear under the rules that he shouldn't be here. And my client is very sensitive to issues like this based upon some of the emails that they have seen where it looks like there were efforts to influence judges before. And we have asked that he remove himself, and we asked that be heard before he's allowed to present any argument.
All right, we're going to deal with the dispossessory towards the end.
Okay.
All right, so let's talk about PFS's objections to some summary judgments. First with the wrongful foreclosure. Hold on 1 second. Good morning. Didn't know I would be going first.
Good morning, Your Honor. My name is Richard Robbins, and along with Josh Belinfante, we represent the defendant, Premium Funding Solutions, or PFS. We will address the wrongful disclosure and quiet title claims, which are exclusive to PFS, but we will adopt the arguments related to conspiracy and the other types of claims to which we are a party, but will be addressed by other counsel.
Okay.
As Your Honor knows, the special master recommended the denial of summary judgment as to those claims. And as we discussed in the brief, and I will just highlight today, the special master respectfully relied on law that was not good. That's been overruled. Overlooked the material undisputed facts, and even relied as to value on an expert presented by the plaintiffs, which in fact was withdrawn by the plaintiffs. And his opinion obviously can't be considered if it had any weight to start with. Quite frankly, this was a result-oriented decision, which I understand, but that, of course, is not what the court should be looking at. We need to follow the law here. We have briefed the matter extensively, but the material facts are undisputed. And Your Honor has already made findings of these facts in its order of February 9th, 2012, to the extent there was any dispute, which there reasonably cannot be. The task force borrowed the money. There's no dispute about that. The money was due, the loans were due 2006, years before any conspiracy is alleged. The task force already wasn't paying its bills, its loans, before my client, much less any of the other defendants, were ever in the picture. The task force entered into 2 forbearance agreements acknowledging it was in default before we ever entered the scene. The task force agreed to repay the loans under the forbearance agreement by February 28, 2010. There is no dispute, the task force did not do so. They did not cure their defaults. They did not pay the loans when due or at any time up to and including today. You also found that Ixis acquired the notes. Nothing wrong with that. It happens every day, every single day. The notes were assignable. The money for the acquisition came from PFS. There's no dispute about that. PFS put up hard money, $800,000 or thereabouts, to fund the purchase of the notes. As Your Honor noted, after proper legal notice, and I'm reading from your order, Ixis foreclosed on the property May 4th, 2010. Ixis secured its loan from PFS with a deed to secure debt. Ixis defaulted, and I'm reading again from your findings, in 2012. Ixis gave a deed in lieu to PFS. There is nothing wrong with this. This is a series of transactions that happens every day of every week in the state of Georgia and elsewhere. Those are the basic facts. We are the record title owner of the property. PFS is. There's no dispute about that. You go to the courthouse, look in chain of title, we own the property. We have a deed. The task force has no title, whether it be recorded, prescriptive, or otherwise. The task force to this day has neither paid a penny on the loans, and critically, for purposes of wrongful foreclosure law, it never tendered the amount due, which is, under Georgia law, an absolute requirement for asserting a wrongful foreclosure case. So let's go to the wrongful foreclosure. This is not a complicated case. The first argument and the fatal argument is the task force did not tender the purchase price as a condition of pursuing a wrongful disclosure case. Case over. We cited, to Your Honor, in the brief, the Caesar versus Wells Fargo case, which is 322 Georgia App 529. It's a 2013 case, which was won by the task force's own law firm, Baker Donaldson, correctly won. And they didn't just win, defeat the wrongful foreclosure claim on at a trial. They defeated it on a motion to dismiss because there was no allegation of the tender of the loan amount. The appellate court affirmed the motion to dismiss. That's the law. That's the law that Baker Donaldson asserted, and that's the law accepted by this court, the Court of Appeals, and the Supreme Court time and time again. Now, the special master relied on basically three cases. One, the Bennett case, which is a 1905 case. A 1905 case, which has been contradicted by over 100 years of Georgia law. And I might, if Your Honor, hand you a case that was decided 5 months ago by the federal court, the Northern District of Georgia, which again granted a motion to dismiss against a wrongful foreclosure case. A motion to dismiss because of a failure to allege that the foreclosed party tendered the amount due on her loan. And what is instructive about that is the plaintiff in that case made similar arguments about impropriety of the note holder, and the federal court said Georgia courts routinely require plaintiffs to make sufficient tender before they may have a foreclosure sale set aside due to an alleged defect in the foreclosure process. And what is instructive is the footnote. And apparently the Benedict case goes around anti-foreclosure circles, because what the court says on the last page is the plaintiff cites to Benedict to support her claim. And the court says, to the extent the plaintiff's reading is accurate, that decision issued over a century ago is contradicted by far more recent authority from Georgia courts. And that is true. The uninterrupted position of the courts, the appellate courts, have said that this is a requirement, notwithstanding what the Supreme Court may have suggested 109 years ago. The second case that the special master relied on was a dissenting opinion in the Giordano case. The majority opinion goes our way, and the special master chose to cite the dissenting opinion. And the third case that the special master relied on, the Holbrook case, went our way. The Holbrook case recognized that there was a wrongful foreclosure claim. Why? Because the person would have gone to the foreclosure and bid more than what was paid for their property. There was testimony to that effect. More importantly, the Holbrook court noted that the borrower tendered the amount due on the loan, and that was refused. Those cases support us, not contradict what we're saying. So that is really a motion to dismiss issue, Your Honor. The courts, as you will see in the cases, have considered claims by borrowers of every type of variation of which the task force's claims are one. All types of excuses why they shouldn't have to tender these sales proceeds. And time and time and time and time again, that argument has been rejected as a matter of law by the Georgia courts. The second reason that there is no claim here is that the only reason that they cite that there's a wrongful foreclosure is that Manny Fialco allegedly told them that he will see if he can get the foreclosure put off. That's it. In the first place, that's way too vague to be enforceable. The Phillips case that we cited in our brief is right on point. People say that all the time. Well, the banks told me they wouldn't foreclose. The banks told me they'd give me more time. The courts of this state have held time and time again. That's not an enforceable promise. The second is, even if he said it, so what? It is undisputed in this case, undisputed, that the task force was not prepared to go to the foreclosure and bid anything. Nor was anyone prepared otherwise to go to the foreclosure and bid on the property. That is not disputed in the record. They have come forward with nothing to show that whatever...
And you're not going to disagree with him, Mr. Hall, right?
I completely am on virtually everything he has said, starting from the first comment, which was a fabrication.
Well, your argument all along is you've been prevented from doing all these things he talked about because they colluded to drive your funding and to purchase the notes and the like.
That's
right?
completely correct.
So that's why I was asking if you would agree with what he's saying, that you didn't do all these things.
No, well, I agree that we have not tendered up the money. I completely disagree with his interpretation of the law, and I completely disagree with his factual statement that nobody would have been there to bid, and I completely disagree with his factual representation in the brief that nobody would have done anything about the foreclosure, because I stood on the courthouse steps with the motion for TRO when Manny Fialco tricked the chairman of the board into instructing me not to file it.
All right, I'm going to come back to you. I'll come back to you. Thank you, Mr. Robbins.
Well, fortunately, we have the evidence and the law to go by, not Mr. Hall's statements. And another thing I will just add is he shouldn't be sitting at the trial table. He's going to be a witness at the trial. The third point on which there is insufficient or no evidence to support a wrongful foreclosure claim is that grossly, you have to show that the purchase price of the foreclosure was grossly inflated. We all know, and as even the special master recognized, particularly in this time frame, virtually every sale went back to the lender. It was bid in by the lender. There is no expert testimony as to any gross inadequacy of the price paid. The special master cited to an expert, which has since been withdrawn, and for good reason. The other evidence is not evidence at all. A broker speculating that the property may be worth $4 to $8 million, a heck of a range for a opinion of value. And then there was an offer with conditions earlier, or a year earlier, by Mr. Fiacco. That was one. An offer is not admissible evidence of value. We all know that. The best evidence we have is there is no bid beyond the loan amount at the foreclosure. There's no appraisal in the record, which stuns me, because I've done an awful lot of wrongful foreclosure and confirmation proceedings. There's no appraisal saying it was worth more. They've had 4 years of litigation and no appraisal. They had one expert who they withdrew. So those are 3 independent reasons based on the undisputed facts in the record, not what counsel disagrees with, not what he contends is fabricated. That's what the record says. And there is nothing in the law other than a vague sense of equity, which can hardly override all of Georgia law, supporting the wrongful foreclosure claim. There have been many, many reasons why people have gone into foreclosure because they can't pay, and many heart-rending reasons: losing jobs, losing loved ones, medical bills, improper acts done, and many of these cases involve contentions like the task force contentions here, that the lender did something wrong. I mean, this is not a unique case. In the federal case I just read you, that was another case. The lender does something wrong, the court says, too bad. You still have to tender the purchase price. I'd like to address briefly the quiet title. You mentioned wrongful foreclosure. The quiet title is simply the same claim in another guise. It really is the same as a wrongful foreclosure claim, and it should be dismissed for the same reasons. But let me address very briefly. Under quiet title law, you have to show superior title. And I've had those cases where there's some technical glitch, so forth, in the title. The case law is again clear on that. It can be a descriptive title, it can be title of record, it could be a misnomer or misnamed, it could be an unfiled title, that kind of thing. The task force here doesn't come close to showing that it has a superior title, and that's a matter of law. It has no title. It is not the record owner. It claims no title pursuant to prescription or any other basis. It has no title at all. We got the title through the standard process of buying a loan, financing that, foreclosure, non-payment, and it's in the chain of title. They have zero title, colorable or otherwise, to this property. All they have is an argument, a claim of a series of events that would have left them with title. But for this conspiracy, they would have had the money, and they would have used the money to pay the loan, and would have not been foreclosed on, even though for 3 years, at least before this alleged conspiracy, they still weren't paying the loan. That's an argument. That's not title. There's nothing to quiet here. We have title of record, and there's nothing to quiet. Respectfully to the special master, we need to follow the law. We need to follow the correct law, not the wrong law, not incorrect citations to the law. The law applies whether it's to, and the same law applies whether it's to a homeless shelter, someone's home, someone's factory, a strip club, or a church. We are all equal in the eyes of the law.
Thank you, sir.
Thank you, Your Honor. Your Honor, I note that Mr. Robbins has backed away from what he was saying in his brief, which was that the special master was incompetent, was so biased that he made up facts. And I'm not surprised he's backed away from that now that he's got to stand behind it and say it. But I will say this, I have never in my career had to get up and say that virtually everything from the first word that I just heard was fabricated. The first thing he said to you when he stood up, there was no evidence of value, there was only some report that was struck. It's completely false. It's a misunderstanding of the law, and it's because he didn't even bother to attend the deposition. The evidence of value came from Gene Kansas. He was the broker who was selling the task force's building. He put a value on it at $8.3 million. It was in a deposition. Every other defendant was there. Mr. Fialco was there. So I've cited this to Mr. Robbins now 5 times, and he is in his brief saying the special master is a crook and incompetent because he relied on things that Mr. Robbins could not know are in the record. Now, to the extent he wants to intimate that we had to have expert testimony, you notice that he didn't quite get up and say it. He wants to intimate that there needs to be expert testimony. Well, I've cited him the law 4 or 5 times also, and this is it. A party seeking to confirm non-judicial foreclosure sale is under no obligation to present an expert appraisal of the property. Direct testimony as to market value is in the nature of opinion evidence. One need not be an expert or dealer, but may testify as to its value if he had an opportunity for forming an opinion. Of course, opinions of experts can be important. So all of this is made up, and it is indicative of everything that has happened so far. We got 300 pages of briefing trying to argue that there's no factual issue here. All right, with that said, Your Honor, I would like to, Mr. Robbins very carefully started in the middle and didn't go through and skipped over all of the evidence of what had happened and all of the evidence that the special master spent months and wrote a 100-page report. A 100-page report from somebody like Frank Strickland. He skipped over all of that to jump into these accusations about Mr. Strickland and these incomplete statements and just false statements of the evidence. But let me just begin from the beginning. First of all, let me introduce my co-counsel. I think Your Honor knows him. This is Robert Brady. And I have brought with me today Jim Beatty and Anita Beatty to sit with me at the counsel table. And these people have been much maligned throughout this case from the very get-go. With whispers, they were maligned by the defendants in secret to other people. They've been maligned in filings. And let me just introduce them quickly, Your Honor. Dr. Beatty is an English professor. He has a PhD in English. He has a master's in theology. He taught school at the University of South Carolina. He's the author of this book. It's called Sacred Grammar. What he has done is he has written a book that teaches grammar to homeless people based upon the teachings of the Bible, because he believes that that is the book that these people will be the most grounded in. They use it every day in their GED class, where they teach homeless people, get homeless people GEDs and get them jobs. He drives a 20-year-old Saab. I wouldn't even drive a new Saab, Your Honor. He has been the co-executive director of the task force since 1985. They devote, by my estimation, 80 hours a week to working on this, both of them. They both ought to be retired, but they can't. Anita Beatty, she was brought up as something in a privileged life when she was young. She became an artist, but she began, under the Johnson era, war on poverty, she began devoting her life to helping people that were the most unfortunate and suffering from poverty, and she has done it her entire life. She has been co-executive director of the task force for more than 25 years. She's been the president of the National Coalition for Homeless People that represents homeless people not only all throughout this country, but all over the world. She drives a 1983 Honda Accord, Your Honor. And the reason, I'm sorry, Honda Element. And the reason she drives that is that she needs something that she can go out and get homeless families and get them help in. We took her deposition in this case. She got a phone call in the middle of the case from a newly homeless family with little baby kids stranded in Smyrna, left the deposition after 9 grueling hours, got in her Honda Element, went and got that family, brought them to safety, fed them pizza, gave them clothes, and got them a place to stay. That is the type of people that we have been maligning throughout this case and since 2006. Quite frankly, Your Honor, in my career as a lawyer, I have never been as privileged or as honored to work for people like these people and to work for the organization that they carry on their backs in their mid-70s, because they are so committed to helping the people in our society that need help more than anybody else. Now, what does the task force do, Your Honor? Last night they had about 400 people, 400 men, and that's in the summer where people don't have to be inside. They had about 100 women and children. These children go from about 2 weeks old up to all ages. They have no place else to go. This year, 3 homeless shelters were closed in the city of Atlanta. 400 spaces eliminated. They only take in women and children because nobody else will take these people. They serve 15 to 20,000 people, 15 to 20,000 people that our society has abandoned every year. They have touched the lives of hundreds of thousands of people, hundreds of thousands of people. These people, the evidence is littered with these people saying all they want to do is warehouse homeless and throw them in to perpetuate their own organization. It's absolute and utter nonsense. What the evidence shows you, Your Honor, in this case, is they have GED programs, they clothe the homeless, they feed the homeless, they train the homeless. My goodness, they've got urban gardens up on the roof of their building training homeless people to be, people who are experiencing homelessness, to be farmers, training them to do construction. All of the programs that we are doing in this city started with them. They give MARTA tokens, started with them. They give transportation to homeless, started with them. They have clothing banks to clothe people so they can get job interviews, started with them. But at the end of the day, these folks are a charity. And what you're going to see in the evidence is that these defendants think they're a star chamber. They think they get to decide. Where this all came from, is they think it's up to them to decide who gets to do what in our city. You can even see in the evidence, and I'm going to show Your Honor this in a moment, where they sat down and they said, is there a legal way to get rid of them? And when they found out there wasn't, that's when they launched a campaign to go after them secretly. Now, this case, to me, has been incredible, Your Honor. It's quite frankly, it's been incredible. Not only from the fact that I've got 300 to 500 pages of briefs trying to tell the court that there's no fact in this case that warrants going forward, but to the pure and utter acrimony that has occurred in this case. Your Honor has been the victim of it, where there are affidavits filed saying that you made patently false statements. Well, I'll show Your Honor where the person who filed that affidavit months before had done exactly what you said he had done, and I'll show you his email. It was a lie. The special master has been the most recent victim of it. A man like Frank Strickland, incompetent, so biased that what he's done is amount to ex parte communications and illegal activity. That's what Mr. Robbins has said in the case. I have to take depositions in the special master's office so that nobody takes a slug at me in some of these instances, Your Honor. Why do we have this? Why has this happened in this case? I'll tell you why it's happened in this case. It's very, very simple. They got caught. They thought, borrowing from their own words, they thought they had everything hidden under a cloak of darkness. But we got their emails, and we got caught, and they got caught. Not only did they get caught, but they got caught doing something that is morally reprehensible. They got caught using all of their power, all of their money, all of their influence to hurt the least able to defend themselves in our society. And let me tell you, folks like this don't like it when they get caught. And when they get caught, they lash out at everybody that they can. That's why we've had what we've had in this case. Now, with that said, Your Honor, I want to bring a little bit to the court about what Mr. Robbins wants to skip completely over, and did skip completely over. May I approach, Your Honor?
Sir, sir.
Your Honor, we probably have 1 million pages of documents in this case. I probably got 400,000 pages of emails and attachments from CAP alone. The Special Master did a Herculean job of going through them. There is no way I can present all of that to you in the time that we have. I know you're busy and I know you have full counsel today. But what I have done is I've put together some stuff that touches on exactly what it is that we're dealing with. And I'm going to go through it quickly, Your Honor, but I think it will be very illustrative, and it'll get to the very things that Mr. Robbins and the others want to keep from your eyes in this case. All right, Your Honor, at tab 1, I've included tab 1. It's an email from A.J. Robinson. He's the president of Central Atlanta Progress, and I'm going to focus on the first sentence. The reason I've included it is it gives you a little flavor of the Star Chamber mentality and what these folks are that we're dealing with. Mr. Robbins' organization got an email from Charles Steffen. He is a Georgia State fully tenured history professor. Very reasonable person, very big person in our community. And what he said is, let's have a roundtable discussion. Let's deal with this issue of homelessness. What is the attitude that A.J. Robinson adopts about having a conversation in a public forum? If we do something like this, there need to be ground rules. Otherwise, it will just give these nuts a forum in front of the media and we lose. Well, A, what do you mean nuts when you're talking about a Georgia history professor? And B, why are you so worried if they're going to bring out stuff in front of the media unless you want to keep it from the media? That's kind of the mentality that we're dealing with. Now, in the interest of time, I'm going to jump forward a little bit, and I want you to go, if you would, Your Honor, to tab 3. Tab 3 I included in this because it shows you the mentality and how these guys operate. Tab 3 is a series of emails that came when a city council member, rather than voting on a vote that would have really been damaging to the homeless, when what he did instead was, he said, I'd like to study this a little more. This is what the defendants engineered with their group of businesses. Lamar, city council member, I want you to know how extremely disappointed the Chamber of Commerce is in your vote. After more than a year of working in countless meetings in the open of the city's new homeless facility, for you to vote to postpone, just postpone, and table the issue to study it is just wrong. You should know that this vote will be remembered by our business members as you face re-election, and we will share it with all 4,000 businesses. A.J. Robinson's response: thanks, Sammy, we're keeping the pressure on. This is how these people believe they are entitled to operate. This is what my folks were confronted with. And if I could go back in time and tell them one thing, I would say, watch your back. These people are not who they seem to be. All right, now, tab 4, Your Honor, I can show you the day the conspiracy started. Mr. Robbins keeps citing vague notions of conspiracy, this, that, and the other. And I'll tell you, it's kind of incredible because although you'll see they did everything they could to hide it, they couldn't, and I got it. Email, Horace, titled subject. This is titled subject, meeting about Peachtree-Pine. This coming Monday, October 23rd, 12 to 2, there is a quote-unquote brainstorming meeting at the Central Atlanta Progress offices that the mayor's office is hosting to discuss Peachtree-Pine. This is when it started. How do we know? Tab 5. Now, everybody, when I took the depositions, became significantly forgetful about what had happened at this meeting, but fortunately, there's a record. Things people were going to, it's titled reference, Brainstorming Monday. Things people were going to look at. Look at emergency shelter standards. What does that mean? That means they want to see if they can kick them out because they don't apply the correct standards. What is required to declare it a public nuisance? It says about halfway through. That's a perfectly legitimate question. Both of those things are legitimate. You've never heard them file a suit for a public nuisance. You've never heard them bring a complaint that we don't meet the standards for an emergency shelter. It's because they can't. So what did they do? They went with their next portion. Who is on the board of directors, and this is the third tab down, who is on the board of directors of the homeless task force want to go to the source of their resourcing and or political support? Well, now people might say, well, that could be innocuous, that comment. Let's go to tab 6, because here's where they start really letting it out. Top email, 4th paragraph. A.J. Robinson, Brad Curry, and I went to talk with Dan Cathy yesterday about our concerns with the operation of this shelter and the disservice they provide to the community. Now, both neighbors and the homeless themselves. Now, I'm going to show you in a little bit where they had no idea what the task force operations were at all. This was just a fabrication. Dan Cathy has given money to the shelter and even volunteers there, including staying overnight there. We hopefully made an impression that there is another side to this operation that he might not be aware of. So let's summarize this. What have they done in this email? They've told us we identified a business relationship that the task force has, and we've decided we're going to insert ourselves into it, and we're going to do it by saying negative things about the task force and the disservice we perceive. How do they do it? What are they trying to do? The effort is to both shut off public funding to the shelter and to try and impact private funding as well. Hence the visit to Dan Cathy. Could you be any more caught? I don't think you could. It goes on. It's too early to tell how this will affect. This will take more time and continued pressure. So we're going to keep doing it and keep doing it till we win. Now, if you turn to the next page, you get a little bit of a flavor of how they realized they were being successful at what they were doing by 2007. Here's an internal CAT meeting. A.J. Robinson is there, Debbie Starnes, who they brought in from the mayor's office, Horace Sibley, who they brought in from the mayor's foundation, and look what they're saying. First paragraph, exposure for what the City Gateway Center are accomplishing. Well, we need more outward release of information into the media to balance and put in perspective against what the task force is doing. Need dedicated professional PR assistance that deals directly with Homeless Commission Gateway. What do they want to do? They want to hire PR people to go after us, and you're going to see that they did. You're going to see what they said in the newspaper. Impacting task force funding. V. Wardlaw and Two Sisters, our primary funders. Our major funders through the foundation. Dan Cathy, Chick-fil-A, also major funder. Research needs to be done on smaller funders and who could possibly approach them. Could you get any more caught? Transition plan for major funder. This is Dan Cathy. Sibley has talked with Cathy and he is now more informed. What does that mean? What is that code for? Well, we've told him all kinds of bad stuff. And then if you go down to the bottom of that, you'll say, you need to flesh out how Cathy could do this, stop funding, and save face in the transition. That's what we're dealing with. We are dealing with the powerful, behind closed doors, going around behind us. Tab 8, Your Honor. Did they know it was right? Did they think it was right? Did they think what they were doing was legitimate? Last paragraph, last sentence of, full sentence of tab 8. Of course, all of this has been under the cloak of darkness and virtually no emails back and forth to the city just in case of FOIA. They're worried it gets out into the press because they know it's not legal. They know it. This is the kind of evidence that Mr. Robbins is willing to get up and tell you that the special master was competent in denying, incompetent because he denied summary judgment in the face of this evidence. The next tab, Your Honor, is kind of an important one because I want to show you just how nasty they got. This is long before my involvement. The next tab, Your Honor, is an email from Richard Orr, the special project manager that CAP assigned to do this work, to commit the assassination. And he's emailing Debbie Starnes at the city, and what he says is, we just need a clarification before we pull the pin. What's he talking about? Dropping a hand grenade is what his allusion is. What's the pin he's going to pull? What's the hand grenade he's going to drop? Call to the press. Lori just got wind of this late yesterday with angry calls from residents and businesses in the area around Peachtree-Pine homeless shelter. Supposedly Fulton County Health says they have no jurisdiction but are issuing a letter titled, "Call Me About a Massive Body Lice Infestation in Sono." That's the area right around Peachtree-Pine. You know what the problem is? If you flip to the next page, well, hold on, the next page is what they do once this happens. The next page is the News Archive article that comes out. And look what they say. Right now it seems to be escalating at the shelter of Peachtree and Pine. If it spreads everywhere, it's a logistical nightmare. And it's a financial nightmare for these agencies. This is what they're putting into the press. So the entire community thinks this is true. A.J. Robinson, the issue, lice, is symptomatic of a much bigger issues with the operation. Somebody needs to have responsibility for health-related issues at the shelter. We turn to the next page. You know what the problem is? The whole thing was a lie. There had never been a lice outbreak. This is Fulton County Health Department's memo. It says, "I am not aware of any health official declaring a lice infestation at the Peachtree-Pine shelter or any other shelter," it says in the middle. Their PR people that they hired and paid a fortune cooked up the worst kind of lies they could cook up to destroy all of our funding. Now, the next tab I've included, Your Honor, and I'm going to move a little quickly because I want to get to Mr. Robbins' specific arguments because they have zero merit. But the next tab, tab 10, is an internal executive committee and board of directors meeting notes from November 8th to 12th of 2008. Now, by this time, they had been beating up the task force's finances for 2 years. 2 years since the October meeting. I include it because it shows you when they decided our next step is to attack the notes. Let's go get the notes and foreclose on the notes. If you turn to the next page, Peachtree and Pine Shelter Update. Robinson reported on several issues relating to the financial viability of the task force. He was probably well suited to report to those issues, Your Honor, because he was the one who created them. Tom Bell and their possible default on more than $800 in loans from Mercy Housing. Tom Bell suggested that it might be possible for the loans to be purchased from Mercy. So this is where they put it together. We've now cut off all their funding. And Your Honor, what the evidence is indisputed. Their funding for 2006 was $1.7 million. Since then, their yearly funding has been less than $300. I think this year was $200. 200. That's how incredibly effective. And because we don't have title to the property, as Mr. Robbins says, we can't get government grants anymore. It is all spiraled in on itself, and it was all triggered by these guys. All right, I've included tab 11 because it shows you the notes from Mercy Housing. Now remember, they had already inserted themselves into the relationship with Dan Cathy, the relationship with the general public through media publications. This is where they start inserting themselves into the relationship with our lenders. Now, it's been argued in the briefs that they were invited into this relationship. It's nonsense. Each of them have admitted we had no relationship with the lenders prior to this. Here's what they start saying, and I won't delve on it, but what these are the notes from our lender, where they're quoted as saying, task force wants to shelter, feed, and nothing else. In this business, that's the worst thing you can say about somebody. These guys are doing everything they can to build people up, and they're insulting them and saying that they're not. Shelter's poorly run, all of these things. Now, they argue that this didn't have any effect on anybody. This didn't do anything to anybody. Well, if you turn to tab 12, what we have is the email from the chairman of the board, a nun, the chairman of the board of Mercy Housing Southeast. Julie, I got your voicemail. Thanks. I wanted to talk to you about the possibility of foreclosure on the Peachtree-Pine property in Atlanta. I've talked with Pete and with others representing the city, A.J. Robinson, and believe that foreclosing is what we should do. Down a little farther, moving the men is very doable and represents a philosophy that I think is much more enlightened than warehousing them in the present facility. Well, where did that warehousing concept come from? It came from these guys. Did it cause an effect? Heck yes. You can't get better evidence of this being what caused the lenders to stop thinking about us, unless, except, of course, you read my evidence where I've got the affidavit of the loan officer who testified that these comments destroyed the relationship with the lenders. Now, let me move a little bit, and I'm getting more directly at Mr. Robbins' arguments. Mr. Robbins came in here and said, we're ICFIS, we're PFS, we're completely separate companies. We had nothing to do with any of this. Well, tab 13 is where Fialco gets recruited. Thursday, the email in the middle, February 19th, 09. Subject, Peachtree-Pine. Text. The question he got is, the task force is trying to sell their building because their finances have been so decimated and they don't know what's going on yet. They're trying to sell it. Mike Dinnerman, down at the bottom, sends out an email to Manny saying that, hey, do you want to look at this building? Manny is one of these downtown developers, Manny Fialco. His response, A.J. Robinson pitched me the deal this morning. Let's look at it next week. Well, A.J. Robinson has only one agenda at this point for pitching the deal to Mr. Fialco. He wants the task force out. Now, the next tab, FYI, please keep confidential. I know Fialco pretty well. My guess is he would come up some on price after he makes a lowball offer. We may be able to convince him to buy the notes if nothing else surfaces. So they're roping him in to the job. The next tab, tab 15. By tab 15, we know Manny is fully on board. Mr. Fialco is fully on board. Look what he says to A.J. Robinson. Note of potential importance down at the bottom. Michael Weinstock was the campaign chair, and let me preface this. Let me preface this with saying I have nothing to indicate that Michael Weinstock, and I regretted to hear that he passed away, I have nothing to indicate that Michael Weinstock bought into any of this. I have nothing to indicate that Judge Bedford bought into any of this. I put it out there because what it shows about Manny Fialco's mindset. Michael Weinstock was the campaign chair and hosted the campaign of T. Jackson Bedford, the judge who turned Anita's water back on. If need be, I can get him to make a call or show up with Troutman or even take that part of the case if it comes up again. Well, why is he offering that? He's trying to peddle influence. Who peddles influence if they're not involved in the conspiracy? What does he say at the bottom? I will continue to quietly attempt to come up with alternatives, them, including buying single-family homes or small apartment buildings in an area not too far from, but far enough from downtown. What's he trying to do? He's trying to cover their backs so they can take the building and he can say, look, we got these other places to put these people. Of course, he never did. Now, tab 16 I include because it is the beginning of something that Mr. Robbins chose to ignore. The issue is, was there anything that interfered with the foreclosure? Mr. Robbins told you, there was a comment from Manny Fialco, that's meaningless. That ain't the half of the story, Your Honor. Gene Kansas said the two primary buyers, or the primary buyers for this property, he's been doing this for 10 years, he's had 400 transactions. The primary buyers were Cousins Property and Emory. What this shows you is that by 2009, these guys were already making deals with Emory to flip the property to Emory. Well, and I'll show you later on in this where Manny Fialco was proposing deals to Emory at 8:23 in the morning before the foreclosure sale. The law in Georgia is dead clear. You cannot interfere with the sale. You cannot collude with potential buyers, which is exactly what they did and what Mr. Robbins doesn't want you to know. You cannot collude with them to try to depress the sales price. That in and of itself kills their argument, in and of itself. Now, if Your Honor, just to jump ahead a little bit and show you where that I'm not lying about the Manny Fialco, the last tab on this book, tab number 28, is Emmanuel Fialco. The foreclosure day was May 4th. May 4th, 2010. I don't know what time the foreclosure sale actually occurred, but I know it was after 10 o'clock, because I believe that's when they have to do it. I said 8:32. It's 8:52 a.m. Manny Fialco is writing to Dane Peterson striking a deal, working on a deal to flip him this building. Now, he's certainly going to deny that that's what that was, but when you read the 50 emails between all of these guys in Emory of it talking about flipping it to Emory, that's what he was doing. When you're a foreclosing party, you stand in the shoes of the party that owns the property. You have an utmost duty to conduct the sale in good faith. You can't do anything that depresses the price. He's talking to the primary buyer. You know what Emory ended up having to do is they had to build a Proton Center someplace else. This property is directly across from them. And he's influencing Emory the morning of the sale. That kills everything that Robin said by itself. By itself, that kills everything. Tab 17, Robinson, to Cousins Property, which is Emory's development partner, if I remember correctly. Agreed, talking about Manny Fialco. The remark is Fialco has become so happy that he's going to make a windfall on this that even his co-conspirators make this comment. This gent is way down the road on this. You've got him pretty lathered up. AJ's response, agreed, but he just smells a deal and will flip to Emory if we want. Also, he tops out at about $2 million, so we may need some backup. Is there any more better evidence that these guys are working together to do this? I mean, could it happen? There couldn't be better evidence. Well, maybe there could. Tab 18. A.J. Robinson to Dane Peterson. Sorry for not catching you by phone, blah, blah, blah. Is there any value in figuring out how to buy the note with Manny? Perhaps, this is Emory to A.J. Robinson. A.J. Robinson's response, perhaps possible. Manny could buy at par as well, but he rightfully feels like there should be some discount if he was the one to foreclose and kick them out. This thing was the plan from the get-go. None of this has been a legitimate transaction. The whole thing was a setup from 2006. Now, I'd like, Your Honor, if you would, I'm going to turn to tab 20, because I want to show you just a little bit of more clearly what we're dealing with here. Tab 20, Your Honor, is an affidavit under oath that Mr. Fialco submitted in order to get you recused from this court because you had the audacity to state an opinion that was against his position way back in the beginning of this case. And I'm looking at paragraph number 28, Your Honor. And this was from a June hearing, I think it was in 2010. I'm sorry, it's 2011. Paragraph 28. Under oath, I also heard the court say, quote, can we sit out here and let's be real that Mr. Fialco and his group put up $900 for a piece of property that is worth $4 to $5 million. That's what he said. His next paragraph. This was a blatant and patently false statement made by the court. I did not put up any money for the property at 477 Peachtree, nor do I have any control over any group that did. Now, Your Honor, if you would, turn with me to tab 21. This is Mr. Fialco's email to the bank on the day that they purchased the notes. Julia, and I'm looking at the second email down. Julia is the bank representative for the bank. Please take the sum of $780,000. Wire the sum of $780,000 to Sam Feldman's escrow account, ASAP, from Stacy's account. Stacy is his wife. This is similar to before, so I am including the info from a previous email. This is what I have dealt with from day one in this case. It's true about every single thing just about that has been said. It is all a fabrication, and they know no bounds on what they will say. I don't think I've ever seen anybody who's had the cojones, quite frankly, Your Honor, to accuse the court of lying when they know that they did it. They know they did it. It's just frankly, it's been incredible. Now, to show you the other thing that lets you know that this is an absolute farce, tab 22, Your Honor, is the note. Remember, Mr. Robinson, PFS has nothing to do with any of this. ICFIS is one company, PFS is another. Well, let's take a look at the note that he claims. Of course, remember, he did say that nobody disputes. I think Mr. Robbins' argument was nobody disputes that the money came from PFS. Well, we now know that the money came from Stacy Fialco. It did not come from PFS. That was a fabrication completely from the get-go and still is. How else do we know it's a fabrication and the whole thing was a scheme? The promissory note. It says at the top, tab 22, it says at the top, $900,000 is the amount. If you go down a little bit farther, in the middle it says $980,000. If you go on a little bit farther in the parentheses, it says $780,000. I'll tell you, I mean, people may have money, but I have yet to find somebody who signs on to a note that says the amount is somewhere between $980,000 and $780,000 unless it's all been a backdated fraud. And the jury is going to find that. The whole thing has been a fraud. Now, Your Honor, also included in here is something, let me just flip to it, and then I'm going to put this book down for a moment, because I know I want to address specifically Mr. Robbins' comments. If the court chooses to look through the remainder of the binder, Your Honor, you will see where these guys paid a city official $40,000, funneled through because they wanted her to continue to do work for them. It was Debbie Starnes. The special master found that was evidence of bribery. I submit it here because it is very clear that that's exactly what they were trying to do, is they were trying to buy influence in the city. But tab 16, Your Honor, is the last one I want to talk about specifically, and I want to direct it specifically towards, again, Mr. Robbins' remarks that Ichthus Community Trust, a Nevada trust, is a separate and legitimate entity. PFS is a separate and legitimate entity. Here's what Mr. Fialco said at the very beginning in his email to A.J. Robinson and others on the second page, discussing this transaction. I welcome the opportunity to remain in the background so long as possible. Wonder why. We are thinking about having a Florida or Nevada trust be the sole member of the LLC, and the manager will be a separate out-of-state LLC. I have this structure in another deal present. They have been, there's no other way to put it, they have been lying to this court from day one when they say that they are something other than all of a conspiracy, all made up by Manny Fialco. The whole thing has been a fabrication. And it is one thing to have a fabrication, for clients to have fabrications and things like that, but to accuse special masters and people in the context of this evidence, I've never seen it. All right, now, Your Honor, with that said, let me address their specifics of PFS's argument, and I'll tell you, I don't know if the court reviewed, I know that there was a flurry of activity that came in at the end. I don't know if the court has reviewed my specific response to the PFS objection. However, it's dead on, and it's, quite frankly, it's right, Your Honor. Okay. I've already discussed, he made 3 arguments today, and I'm going to focus on the 3 arguments he said. He said there's no evidence of value in the record, therefore the foreclosures, therefore we can't show. And the test is you have to show wrongful conduct and an inadequate price. His argument, first argument, is there's no evidence of an inadequate price because there's no evidence the special master was so biased he relied upon an expert report that was struck. Well, we already know that's wrong, and that's just a mistreatment of evidence. Gene Kansas gave direct testimony. There is no better person in the world who could have testified about the value because he was the broker selling it, and he walked through it, he researched the title, he talked to these people about the value. You don't get any better than that evidence. So that was dead wrong. Second one, he argued, the only bad conduct, they say, is that Fialco said he wouldn't foreclose when he did. Well, that's clearly wrong. Bad conduct, for purposes of this, is not, and by the way, I noticed that he reveled in citing Baker Donaldson's activities on behalf of Wells Fargo. I don't doubt we won that case. I don't doubt we won it on motion to dismiss, and I'll tell you why. Because Wells Fargo did not gang up with a whole bunch of other people and attack that borrower's source of income. They didn't go to his employer and accuse him of taking drugs or doing illegal activity like these guys did. That's not the same case. Now, he said Fialco said he would not foreclose. That's the tip of the iceberg on the wrongful conduct. The wrongful conduct started in '06 and continued up through the foreclosure sale. Now, what he wants to do, what Fialco wants to do, and what the rest of his entities want to do, is they want to divorce themselves from the conduct of the other people. But they can't. And you notice that Mr. Robbins didn't argue this. The law is dead clear, and I'm sure Your Honor deals with this in conspiracy cases all the time. First of all, conspiracy cases are hard as heck. It's hard as heck to get evidence. It's a blessing that we got this evidence. But number two, when you join a conspiracy and you know what that conspiracy is doing, you're liable not just for what you do, you're liable for what everybody did as if you did it yourself. And you are liable for what everybody did before you joined the conspiracy. That's the law. That's what the special master found, and he was dead on correct. So what does that mean in this case? That means that the lender, ICFAS, the real person, Mr. Fialco, they did every single one of those events in the eyes of the law. And when you go to do a foreclosure, you have to be not just fair in the foreclosure sale, and I've cited to the case authority for this in my brief. You have to be fair throughout the whole transaction. You have to have acted in good faith throughout the whole transaction. So what we get as a matter of law, and let me just say this, we're not talking about a trial here. We're not talking about disputed issues of fact being important. If there's any evidence of wrongful conduct, any shred of an evidence, of a piece of evidence of wrongful conduct at this stage, then this thing has to go to the jury. Any shred of evidence of inadequate price, this thing has to go to the jury. And to say that there is not a shred of this is why they have to spend 350 pages briefing, because it's just absurd. Now, so he's responsible for all of the conduct of all of the defendants. Next thing he did, he lied to our chairman. I was standing there, and I would have stopped this foreclosure sale because, Your Honor, I had a lot of this evidence at the time. I didn't know about Fialco, but I had a lot of this evidence in my hands, and I would have gone right down there to the court, and I believe the court would have been as offended by this evidence as everybody else has been when I walked in, and that foreclosure sale would not have gone forward until this had been redressed. And so that lie, in and of itself, kills their position. The next thing he did is what I've said before. He already gigged the deal. He had already been working with Cousins. He had already been working with Emory. They weren't going to come down and bid at this foreclosure sale. It was not going to be a fair, open sale for the public because they already knew he was going to flip on the property. Why would they go down and bid? Why would they bid against each other when they're working together to gig the sales price? Now, if we need any more evidence of an inadequate purchase price, I'll tell you, it can be nowhere greater shown than what we've seen in this litigation. Who slugs, who fights with lawyers, who makes these arguments, who makes these accusations, unless they're going to get a big windfall at the end. These guys know this property is worth about $8.3 million. They gigged it so they could get it for $730,000. They did it with wrongful conduct. And by the way, the standard for what is wrongful conduct, it does not have to be a fraud. It can be a misrepresentation. It can be any predatory act. And if this ain't predatory action, the words have no meaning. They have no meaning if this ain't the picture poster of it. So, Your Honor, that's my response to this argument that there's no evidence that the foreclosure was wrongful. I will be happy to address any particular evidence. It's all in my brief, Your Honor. It's all in the summary judgment briefs. I think our special master did a Herculean effort in dealing with this. And frankly, I was embarrassed by what I saw and the accusations that came out against me.
All right, let's take a brief break, please. Okay, Mr. Robbins, anything further on any of these other motions for summary judgment?
I'll respond for this one.
You may, sure.
Your Honor, needless to say, I'm going to ignore the personal attacks. statements wrongly attributed to me. This is not about me, and it's not about Mr. Hall, it's about the law. And nothing he said changes that law. There was no suggestion that there's law to the contrary on the tender requirement. And there are many, many cases where the lender was accused of improper activities which caused the wrongful foreclosure. The Georgia courts have been very, very clear there's still a tender requirement. On the foreclosure, the comments that were made by Mr. Fialco, you just don't say something happened wrong. It's got to be a causal connection, and that was absent. The theory has now somewhat changed that perhaps Emory would have bid at the foreclosure, et cetera, et cetera. Again, we're dealing with speculation, not with evidence. On the value, a broker speculating, and I commend to you his testimony on it, speculating that maybe it would get 4 to 8 million is no admissible evidence whatsoever. You would never allow a broker to just get up there and speculate like that without any research and a price range like that. There's a reason they didn't get an appraisal here to offer. There is no suggestion that we didn't have the right to acquire the notes secretly, not secretly. Banks, lenders, borrowers, Rialto, everybody does that on a daily basis. Loans, bought and sold. You don't have to have a clear motive to buy or sell a loan or to foreclose if it's in default. There's a lot of sound and fury, in other words, but no law, and ignores the undisputed and, more importantly, the non-speculative and the material facts. And I commend to you those facts, not the sound and the fury. And finally, I just want to reiterate what we have said from the very beginning. This is not about the homeless. They're going to be taken care of. This is about the task force not paying what it owes. That's what it's about. If Mr. Hall or his supporters or his firm want to buy the task force a building and not have the task force pay, that's their prerogative. PFS has a right to use its property, and if they wish, and if they wanted to have a claim for wrongful foreclosure or quiet title, they should have the legal requirements.
Thank you. Anything further?
Your Honor, I would just say this. I think the special master treated the issue of the tender excellently and correctly in his order. And I'll just put 2 sentences in on there. Equity is there for situations, and as a Superior Court judge, you're the judge charged with this, it's for situations where the law doesn't specifically prescribe how you should do things. And the fundamental principle of equity that Mr. Robbins belittles and tries to skip past is this. The only instruction of equity is do what's right. And there is a maxim in equity that says, if you want to come to the court and ask for equity, you must have done what is right first. You got to come in with clean hands. And 99 times out of 100, maybe 999 times out of 1,000, that means the borrower should pay off the note first. Maybe. I don't know how many times. It depends on the circumstance. However, if you are on your way to pay off your note, and I'm a bank, and I sent someone to steal your money out of your car, and I stole all the money you had, would equity say that you don't get to come to court because I already stole your money and you didn't pay it first? That's exactly what the special master saw. He supported it with case law. It's clear as day. And you know, the history of law is filled with lawyers trying to say there are thousands of cases like this. But all you got to do is look at the basic principle. What is fair? If they took our money, can it be fair to require us to pay first? That's exactly how they gutted us. It's just an absurd argument, Your Honor. So the only other thing I would say is I don't think I made personal attacks on Mr. Robbins. I think that to the extent there are any personal attacks that have been in this court case, it is in Mr. Robbins' public filings about Mr. Strickland. And I'm not surprised he wants to gloss over those at this point.
Anything further on these issues?
Not from us, Your Honor.
Do you want to hear from any other summary judgment issues?
Yes, yes. Anybody on these summary judgment issues? I believe there's 4 of them.
Your Honor, may we move in the back?
Sure.
Sure. We're called upon.
Yeah, sure.
I think there's ABID and CAP, Your Honor, and then I think there's also one from Fialco. We are prepared to rest on our briefs with respect to our little one, and we think that it's handled properly there.
Okay.
Your Honor, my name is Gary Knopf, and I'm here on behalf of Central Atlanta Progress, and I'm just going to make a few brief points on the objections that Central Atlanta Progress and the Atlanta Downtown Improvement District filed in response to Mr. Strickland's proposed order on summary judgment on those issues. The first issue I'd like to address is the claim that he denied summary judgment on the tortious interference with Dan Cathy's funding. The second is the tortious interference claim with the task force's lenders, and the third is the tortious interference claim with the Department of Community Affairs funding of the task force. Regarding the first issue, the tortious interference with Dan Cathy's funding. The task force has alleged throughout this lawsuit that Dan Cathy stopped funding the task force after a July 2007 meeting attended by A.J. Robinson of CAP and members from Emory and St. Luke's. You heard that here just earlier. What the task force did not mention earlier, and what they still have not acknowledged, is that a year after this meeting, in July 2008, Mr. Cathy donated another $100,000 to the task force. They have not acknowledged this fact, the task force has not acknowledged this fact in the face of their own records showing this evidence, and also in the face of Mr. Cathy's sworn testimony to this effect. They still have not acknowledged this fact, even when brought forward with this evidence by the City of Atlanta, when the City of Atlanta was in the lawsuit with the task force back in 2011. After July of 2008, Mr. Cathy stopped funding the task force. But the only evidence in the record is Mr. Cathy's sworn testimony as to why he stopped funding. And the reason why this is the only testimony in the record is because when the task force deposed Mr. Cathy back in the City of Atlanta lawsuit, he was never asked why he stopped funding the task force. Now the reason Mr. Cathy stopped funding the task force is because the task force did not use the money for projects that he wanted to use them for. And that is in a March 2008 letter by Ms. Beatty to Dan Cathy explaining how they're using the money. He was also concerned about statements made by the task force's board chair, Mr. Bob Kramer, regarding that the task force was not going to survive. And he was also disturbed that the task force never paid his friends from Gay Construction from doing work on the property of the task force. Now, Mr. Cathy has filed a sworn affidavit in this case, and I'm happy to provide a court with that copy just for the reference. It's been filed already, but this is the only evidence in the case as to why Mr. Cathy stopped funding. And it had nothing to do with anything that Central Atlanta Progress or the Atlanta Downtown Improvement District ever did regarding the task force. That testimony is undisputed, and therefore the tortious interference claim with Dan Cathy's should be dismissed on summary judgment. The second issue I'd like to address is tortious interference with the task force's lenders. In order to have a tortious interference claim in the state of Georgia, you must be a stranger to both the contract at issue and the business relationship giving rise to and underpinning the contract. CAP and ADID were not strangers to this relationship. In fact, the evidence showed in this case, the undisputed evidence, is that Sister Jane Garrity, who filed an affidavit in this case, and I have another copy of her affidavit if the court would like a copy of that. She filed an affidavit in this case saying that she approached leaders of the Atlanta business community for help regarding whether the Mercy Housing should sell the notes or foreclose on the property. The first time anyone from CAP or Atlanta Downtown Improvement District ever met anyone from Mercy Housing was in late September of 2008, and that was as a result of Sister Jane Garrity going through Horace Sibley to reach A.J. Robinson. That was the first time that happened. So because they were invited into the relationship, because CAP is invited into the relationship, there can be no tortious interference under Georgia law. Even disregarding that fact, there is no evidence in this case that anything that CAP or ADID or any of their representatives ever did towards the lenders caused the lenders to sell the notes on the property. Ms. Leavesley, Diane Leavesley, was deposed in this case, and her testimony was that anything that was ever said to them by Central Atlanta Progress or Atlanta Downtown Improvement District, and you heard some comments earlier, she took them as opinions. She didn't take them as an intentional misrepresentation or fraud or any of that. There was no wrongful or improper conduct. And in addition, there's no evidence that the reason why they sold the notes is because of anything that A.J. Robinson or anyone from Central Atlanta Progress or Atlanta Downtown Improvement District ever said. And in fact, Ms. Leavesley says that the reason why they decided not to extend the maturity date of the loan at a certain point was because not because of what Mr. Robinson ever said to her, it was because of the fact that they had difficulty paying on the loan way before this even started, back from 2006. The only evidence that the task force has used to refute this testimony is an affidavit from Raylene Clark, and you heard about this earlier, who was an employee a former employee from the Institute of Community Economics, which was another lender from the task force. Now, Ms. Clark stated in her affidavit that she began to hear from, quote, others at Mercy Lending and ICE negative comments about the task force, and that those statements had an impact on the relationship with the task force. Your Honor, as we've briefed extensively in this case, we believe Ms. Clark's affidavit should be stricken. Ms. Clark is not capable of testifying as to what these unidentified others, what their state of mind is. We cannot cross-examine others at trial to determine the validity of those statements. But again, even if we do consider this affidavit and do consider this testimony, Ms. Clark states in her affidavit, and I have a copy of it, and you were provided a copy by Mr. Hall earlier today. What she says is that in June of 2009, she resigned from the Institute of Community Economics. She's no longer an employee. Now we know it is an undisputed fact in this case that the notes were not sold until January of 2010. She then says in her affidavit, and I quote, after she resigned, she had no further involvement with the task force loan and received no communications from ICE or Mercy about the status. And that is in Clark's affidavit at paragraph 20. How can she testify as to what may have impacted the lenders to sell the notes if she wasn't even present and had no involvement with it when the notes were sold? And in fact, she resigned 6 months before that. So because of their no evidence of causation, their summary judgment should be granted with this claim as well. And finally, with the tortious interference of the Georgia Department of Community Affairs, there is absolutely no evidence in this case that anyone from Central Atlanta Progress or the Atlanta Downtown Improvement District, even knew about the Department of Community Affairs funding the task force. There's no evidence that they spoke to anyone, and in fact, the only evidence that the task force relies on are letters that the City of Atlanta representatives sent to the Department of Community Affairs about the task force's funding. Now this claim, this exact same claim, was brought against the City of Atlanta in the federal lawsuit, and the task force lost because the City of Atlanta officials were found to be immune from this. So how can they now hold CAP liable or ADID liable for the same conduct when CAP or ADID never even knew about it and the city officials were the ones taking the actions? But again, even if we do consider that, the only letters that were sent were these letters sent by the City of Atlanta officials to the Department of Community Affairs providing their opinions on the fact that the task force should not be funded. The special master found that on page 70 of his order that these were opinions stated by the City of Atlanta. Opinions cannot form the basis of a tortious interference claim. You have to have some sort of wrongful or improper conduct such as fraud or misrepresentations. These were statements of opinion. So because of that, summary judgment should be granted with respect to the tortious interference with the Department of Community Affairs as well.
Thank you, sir. Your response?
I hate to say it again, Your Honor, the argument is false. This is what he didn't tell you. Dan Cathy was deposed. This is his testimony. Did something happen that you did not make another contribution after June of 2007? Question to Dan Cathy under oath in his deposition before Troutman became his lawyers for the Chick-fil-A Bowl, before Troutman became his lawyers for discrimination issues for Chick-fil-A. This was his testimony. Did something happen that you did not make another contribution after June of 2007? I had a growing concern about the leadership of the ministry. And when you say ministry, you mean, answer, the task force. I'm sorry, a concern about the task force that caused me to be hesitant. Because of my prior relationship with another charity, I was much more careful and guarded in my comments, in my commitments that I would make and the way in which I monitor various projects that were taking place, and particularly being able to feel confident in the leadership of the task force. So he's telling you he's very susceptible to being careful. He just doesn't want to get out on anything that's risky. Next question. Did something specific cause you to become more careful and guarded? There were different data points that began to give me concern. A real surprise took place in a meeting which I received a phone call from Horace Sibley, one of the primary conspirators, that there were some things that he felt I needed to be aware of in an ongoing confrontation or issues that the city of Atlanta had with the task force, and asked if I would agree to be able to meet with him and some representatives that were in the area. That's Mr. Cathy's own testimony before folks started writing affidavits. That was his testimony under oath. What was the very first thing that caused you to become more guarded in giving things? These guys. This is just a question. They can come back and try to Monday morning quarterback and finesse these things, and you know, I don't know how the affidavit was presented or what kind of time frame Mr. Cathy had, but what I do know is when we sat down in front of him, Laura Sorrell, who's a city attorney over here, was the one who asked him the question. That wasn't even a question from me. Now, counsel just told you we never asked him. He was never asked. Of course he was asked. He was asked right there. And what he answered was, it was these guys. So that's what has been so concerning to me throughout this litigation, is we got 300 pages of briefing that is premised on stuff that is false. It's just false. And when you go through what they said, all you got to do is look at their own notes backwards and forwards, patting each other on the back from having been so successful at convincing Mr. Cathy. It became the model that they used on everybody else. And you may recall that now they want to say, oh, well, he gave money afterwards. His own testimony at the deposition was that he never gave any money. Here's the question to him after the meeting. Do you recall any contribution occurring after June 18th of 2007? That was the date of their meeting. I did not have any record of contribution subsequent to that. That's what Mr. Cathy said. They spent a whole page accusing Ms. Beatty of lying about this in their deposition, when that's what Mr. Cathy said. He gave me a spreadsheet. He did it himself. The man's worth who knows how much, and he took the time to go through and come up with a spreadsheet, and the last payment he had on that spreadsheet was 07. And the only thing he said as causing him to withdraw his support was what these guys did. That's the only thing he said. And to now come in with an affidavit and not disclose to the court, lo and behold, that you guys also represent this guy all of a sudden, and you represent his company all of a sudden, I don't understand. All right, number 2. They were strangers to the deal. This is the premise of why they were not strangers to the deal. This is the premise that they're arguing from you. Horace Sibley was invited to a luncheon honoring him for things completely unrelated to this case. Nothing to do with the task force whatsoever, by the Sisters of Mercy. He came to the luncheon And what they're telling you is that because they invited him to a luncheon to award him for other things, he was free to accuse the task force of anything he wanted because they had somehow opened the relationship for him to come in. It's nonsense. If I take anybody here out to lunch, does that mean that I can go around accusing whoever they know and are doing business with of the most awful stuff I can come up with? Of course not. The law, I've cited to it in my brief, is dead clear. You've got to have a real financial interest to be anything other than a stranger to the deal. Now, if that wasn't all that we had, and let me show you what else they didn't tell you when they came in and made this argument in their 350 pages of briefs, and again in their objections. I asked them about these questions during depositions. Counsel didn't mention it, but I asked. My question to A.J. Robinson: okay, CAP was not a participant in the relationship between the task force and Mercy Housing, was it? Answer: no. Their own admission belies what they're telling you. I asked Horace Sibley, same question. I knew this was coming. I asked Horace Sibley the same question. You are not personally a party to any deal between the Metropolitan Atlanta Task Force for the Homeless and the Sisters of Mercy, are you? A party between them? Yeah, you are not a party to their business relationship, correct? Answer: no. Everybody's known this. Everybody's known these admissions are here. The effort has been, we've got unlimited resources. We'll have 10 associates write 1,000 pages of briefs, and we'll argue anything and everything and see if anything sticks. It doesn't stick. And the special master, that's why, again, I say he did a Herculean job of cutting through bamboozling and flat out bull. Now, third argument. Nothing says they caused the lenders, nothing that they said caused the lenders to do anything or to. Now let's talk about this for a second. And let's start first with common sense. You're in a business relationship with an entity. Somebody's already put them under tremendous financial distress. You come in there and say, this is a third party comes in and says, this is an awful group. You're a charity, you're helping this group, they're not even helping the people they say they're helping. Well, once you've said that, once that cancer has been introduced into the relationship, what these guys want you to believe is, you've got to have somebody who then comes out and says, well, it was specifically because of those comments that I decided to do this. It was specifically, well, of course that's not what the law is. You don't get to go up and introduce a cancer into somebody's business relationship. This was calculated. These guys knew exactly what would upset the Sisters of Mercy. Just like Manny Fialco knew to use a company called Ichthus to trick the Sisters of Mercy. That's what these guys did. It's the whole MO that's been going from the get-go. But moving away from what's obvious and logical, let's see what they said. Here's what the CEO said. I read it just a little bit ago. After a call with others representing the city, I think we should foreclose and get them to something much more humane than warehousing. That's what they told them. It wasn't true. And in fact, if you read the deposition that I've cited in my materials from Mr. A.J. Robinson, what he says is, I had no idea what their programs were. I didn't even bother to look. That's what he said. So they went, I've got them making the comments, I've got the notes from the comments, I've got the CEO from the head of the whole organization saying, I got these calls, I heard these comments, and then tying back her decision to foreclose or sell to the comments, to the contents of what was made in the comments. You can't get any better than that. Except I did. During Anita Beatty's deposition, and you're going to see where they accused me of failing to disclose this witness on my witness list. During Anita Beatty's deposition, they popped out a letter from Raylene Clark Gomes or Raylene Clark, and I can't remember which one it was. And they beat on that letter for ages and ages. Now they're saying that I didn't tell them about the existence of Raylene as a witness. Well, frankly, they're the ones who told me of the existence of it. But nevertheless, who was Raylene? Why are they so? Boy, when we get when we get to their motion to suppress this evidence, you'll see why exactly they want it suppressed so badly. Raylene Clark was the loan officer for the lenders. She was the loan officer in charge of this note. They were meeting once a week on this note. You can't find anybody who is a better witness to talk about what happened and why it happened. This is the person. And they want to say, oh, it's hearsay, it's hearsay. It's pure nonsense. This is what she said. Comments this is how she describes how these comments would affect the lenders, because these are charitable lenders. I mean, these nuns, by the way, Your Honor, this is their pension that they're putting up to lend. You better believe they're careful about this stuff, and negative comments are gonna be like a lightning bolt to the heart of a relationship. Comments that suggested the task force would not be able to survive, was injuring the homeless it served, was disliked throughout the community, or was poorly managed, would have been particularly injurious because they suggest the task force is not actually providing the social good that is at the heart of Mercy and ICE's mission, and that Mercy and ICE may ultimately lose the funds they invested and not be able to provide them to others. So she told us this is the worst type of thing you could say. What does she then say? Starting sometime in September 2008, I began to hear negative comments about the task force from others at Mercy Lending and ICE. Now, these loans are being jointly handled between these two charitable lenders. Comments about the task force being in disputes with the city, being in financial distress, and unlikely to pay back its notes, not doing good work for the homeless, that B. Wardlaw was not willing to support them anymore because of other issues in his life, and that the community felt the shelter was in the wrong location. Well, you know where each of those comments that she began to hear came from? The very text of the notes from A.J. Robinson's letter to the Sisters of Mercy, or A.J. Robinson's phone call with the Sisters of Mercy. So what's happened now is that this has filtered down from the top elements at Mercy all throughout the whole organization about that are dealing with this loan. It's filtered down their comments. This just shows what kind of a cancer they introduced into it. Next, she says, the negative comments about the task force had a very significant impact on the relationship with the task force. This is the loan officer in charge of the notes. I don't care if she quit before the actual foreclosure happened, before the sale of the notes happened. The die was cast and the deed was done.
It's not the fact that they're necessarily true, it's the fact they were made.
Absolutely, Your Honor. You're absolutely correct. So it is not a hearsay
It's not a hearsay problem.
Correct. Among other things, ICE and NHT began to have weekly meetings about the task force, and this is key, and switched from a state of mind where they were supportive of the task force to where they wanted to get out of the relationship. I felt a similar shift in attitude towards the task force at Mercy. Now, nobody's asking this woman to, this is how esoteric they've gotten in their arguments because they're so desperate to keep this out. A, they call it hearsay. Obviously it's not. It's not. The definition of hearsay is an opposite. B, they try to say, well, nobody can get into the head of what Mercy was thinking. This is the woman in charge of the notes. She was there every single day as this was going on. She was on the phone to my client, you know, a million times. She was on every single conference call, and they somehow want to bamboozle you into thinking that this is going to be inadmissible, and even worse than that, you can't even consider it under a summary judgment standard? It's absurd. The arguments are absurd. Final one. No evidence that the DCA, the Department of Community Affairs, stopped funding because of what they did. Now here's what they'll tell you. They're telling you this. Look, you can't tie us to Debbie Starnes. Debbie Starnes is a city official, and I'll deal with the immunity issue in a second. But let's just talk about their first argument, which is there's no evidence that anything we did related to what happened to the DCA. And they say, we didn't know, there's no evidence that we told Debbie Starnes to do anything with respect to the DCA or that we knew anything about it. Now what we're talking about is this, just so that we'll set the context for it. The DCA for 10 years, 15 years, funded the task force every year. Most of the money comes from HUD. And under the regulatory requirements, in order to fund, the local government must give approval of the funding. Well, here the local government gave approval of funding for 2007. But what these guys did is they recruited Debbie Starnes to then write a letter that suggested otherwise. And the letter is in the exhibits. And the letter says exactly what they're saying to everybody else. They just warehouse all these false statements. They're verbatim almost in the letter. And what they're trying to tell you now is there's no evidence from which the special master, I think they said, relied on pure speculation. The letter got sent on May 16th of 2007. Just to give you an example, and again, there are hundreds of these, but just to give you an example, when we go back to tab 9, remember when we talked about pulling the pin and that email between Cap and Debbie Starnes? Exhibit number 9, that email was dated April 10th, 2007. They're already joking about, with Debbie Starnes, about how they're going to assassinate the task force, and they're working together with her in this as of a month before that letter.
With regard to the public funding.
With regard to public funding. There is simply no question that this was part and parcel. I mean, Debbie Starnes is back reporting to them in other emails that I've talked to, reporting to Cap, imagine that, reporting to Cap what's going on in the government. That's how improper this star chamber of a relationship has become by this point in time. So the argument that there's no evidence to suggest that they had anything to do with Debbie Starnes authoring this false letter it's also pure poppycock. And remember again, summary judgment. We are entitled to every single inference we get. The evidence shows the conspiracy was started. The evidence shows they recruited Debbie. The evidence showed they're joking about pulling pins on hand grenades. The evidence shows that Debbie does something consistent with that conspiracy. And the evidence shows that she then writes back and explains what she did to these guys. How can you get any better than that, especially when folks are hiding everything under a cloak of darkness? To come out with when they've told you in their own emails that they're doing everything in secret and suggest that because they managed on one occasion to keep something out of an email it would turn the standard for summary judgment on its head, and it would send this case up to the Court of Appeals and we'd come right back down. Your Honor, I believe. Now, the final thing they say, let's talk about immunity for a second. They are right. I brought this case against the city, and I lost it on sovereign immunity, and I thought I could beat it, but I couldn't. Sovereign immunity is a powerful thing. But these guys ain't sovereigns. They're not sovereigns. They're not the city. And what the rule is that if you join a conspiracy, you're responsible for everything everybody did, jointly and severally and individually. So they don't get, there is nothing in the law of Georgia that says that I can go borrow the immunity of the city because I decided to do something totally wrong. I mean, that would be, you know what that would be akin to? That would be akin to these guys going out and saying, I'm going to steal your money and I'm going to do it and tell a city official about it, and therefore I'm sovereignly immune. It just doesn't work that way. They have no sovereign immunity, these folks. They may think they're the government. They're not. So again, Your Honor, these guys are trying to bamboozle you with with a beating of briefs, and you start reading these things. By the time you get to the end, they want you to lose sight of the actual facts. They want you to lose sight of the actual facts. The facts are clear as day, and on a record like this, and I'll tell you why they're doing it, because they know what these things say. They know what's going to happen when these things get up in front of the jury. They know they're going to get creamed on these things. They know that's going to happen, so they got to bamboozle it away right now. And it just doesn't hang together, Your Honor. Thank you.
Thank you. What about exhibits 48 through 100?
I'm happy to talk to those. Let me just get you my notebook on. Bear with me, Your Honor. There's been so many filings. I got to get to the right one. Disqualified.
Is this associated associated with Ms. Clark's deposition?
It is, a lot of it is, Your Honor. Most of the Ms. Clark stuff turns on the hearsay issue, and I think we've addressed that. If I can go to, okay. I don't understand, I think they've withdrawn, but I may be wrong. There was an issue. My belief in this case has been, you gotta be pretty careful with some of these witnesses. I mean, these are very, very busy people, and we don't wanna burn all these people and make them, I mean, we had the city case, we got this case as an Emory case. Mr. Cathy should not have to testify 4 different times. I mean, the guy is as busy as can be. We took his city took his deposition in the first case. And I immediately, once we got into this case, gave these guys the deposition. They chose not to take Mr. Cathy's deposition. And when we got towards the summary judgment motion, they said, aha, discovery is closed. You didn't take Mr. Cathy's deposition in this case. You can't introduce it from the other case because we weren't there. Aha, we got you. This is part of what's been going on. So I approached the special master and I said, look, I didn't want to take Mr. Cathy's deposition, but they're going to push me to it, and I'd like for leave to take his deposition. They immediately backed off and said, well, we'll accept his deposition coming in this case. Because they knew that if he was sitting there being examined by me, he was likely to say what he said the very first time, and they wouldn't get the affidavit that they wanted. So there's some objection to Mr. Cathy's deposition. Quite frankly, I don't understand what it is, because there's an order from the special master where they agreed that it would come in. That was number 18. Number 19 is the same thing with Horace Sibley. Precisely the same thing. Mr. Sibley is retired from King and Spalding. I mean, putting aside my belief as to his involvement in this case, I also don't think that it was absolutely necessary to pull him in and try to take his deposition again and put him through that. He's right up next to these guys. He's been working with them. I think he submitted an affidavit to them. I'm not sure, but he's been in with them the whole time. So they made the same objection to Mr. Sibley's deposition, which is number 19. They waived that as well when the special master was going to give me leave to take his deposition. Exhibit number 28, this is an official document that was issued by the Fulton County Department of Public Health. I think what they're trying to argue is that because I didn't go depose a witness from the Fulton County Department of Health, that I can't bring this in. I mean, Judge, this is what we're dealing with. Nobody questions that this is an official record. Clearly, that's not a hearsay problem. I don't even think it's not an admissibility problem. And the standard that we're traveling under here, Your Honor, that they want to get you past, it's a gotcha. It's a gotcha. The standard we're traveling under here, Your Honor, is we're at a summary judgment stage. If it is likely to be admissible at trial, it should come in. And I've cited to the cases that say if it is going to be admissible.
I think you're right on the law.
Yeah. Okay. Thank you, Your Honor. The next one, the affidavit of Raylene Clark, we've addressed that, Your Honor. That was number 19. The next one are some emails between the AHA and others in the case. I believe these emails have actually been authenticated in a deposition, but quite frankly, it may be that in the 150 pages of 100 pages of my response, I didn't put the testimony in where they were authenticated, but they're certainly going to come in because the witnesses are here. They're authentic emails. They're going to come in. Quite frankly, that one is under the special master's order.
Any other issues on the summary judgment?
I have a couple brief points in response. If that's
Okay, and the rest are kind of the same, Your Honor. Thank you.
Okay.
Regarding the tortious interference with Mr. Cathy claim, the question that he read to you, Mr. Hall read to you, was about being more careful and guarded. It was not whether he stopped funding, and I encourage you to read his deposition testimony because that question was not asked. But more importantly, they still have not, we're still arguing about this $100,000 that Mr. Cathy donated in July of 2008. He was asked about his records in the deposition that he took in the city case. When he saw other records, he noticed that, and the task force's own records and his records, he's filed a sworn affidavit to say that he donated $100,000 in July of 2008. It's frankly not relevant, the relationship between Troutman Sanders and Mr. Cathy and I don't think we're calling Mr. Cathy a liar here. And so.
You're saying that the subsequent $100,000 donation is very important to your claim?
Yes, Your Honor, because they're claiming that in July of 2007, there was a meeting attended by A.J. Robinson and other members of the community and Dan Cathy encouraging him to stop funding, and that they've cited.
And then he stopped funding.
And then he stopped funding, but in fact, he did not stop funding, and that's all written in his affidavit. And it also talks about the reasons why he stopped funding after July of 2008. And in regards to the tortious interference with the lender's claim, the luncheon that Mr. Hall referred to, yes, Mr. Horsey was invited to a luncheon, and this whole question about whether they were a participant in a relationship as in regards to his deposition that was asked, that was before they received testimony from Sister Jane Garrity to say that they went, Sister Jane Garrity of Mercy Housing Southeast, and by the way, she's the chair of the board of Mercy Housing Southeast, she's not the CEO of the organization, I'm sure that was just a mistake, just to clear the record. So she is the one who came to the business community to ask for help. That is how they got involved. And there was no relationship before that because Central Atlanta Progress had no relationship with Mercy Housing prior to them coming to Central Atlanta Progress. And regarding the causation piece, we talked about Raylene Clark's affidavit a little bit. And just to touch on, there's a couple problems with the affidavit. One, the hearsay and the effect on the listener piece. Yes, that's an exception, but Ms. Clark is not testifying as to the effect on her. She's testifying as to the effect on unidentified others. And she can't testify to the state of mind of other people, frankly, that she doesn't even identify. And also you heard Mr. Hall say that she was the loan officer involved in the whole thing. Well, as I mentioned earlier, she was not employed at the time the notes were sold. She had resigned 6 months before and had no involvement between June 2009 and when the notes were sold. And regarding the District Community Affairs, Department of Community Affairs, tortious interference claim, we'll rest on our briefs with that. And with regard to what Your Honor was referring to with city depositions, just to clarify one point, we brought this to Mr. Hall's attention back in 2012 when he relied on some of that evidence in a motion to dismiss. But regardless, we have since withdrawn that objection for summary judgment purposes and allowed him to use the deposition testimony. And we will stand on our briefs with regard.
Does that get us through everything but the dispossessory?
I think
We've got just 5 minutes, sir.
Go ahead, sure.
Your Honor, may I say one thing? I honestly don't know. Maybe Mr. Cathy is going to come in and show us another $100,000 check. Maybe he made a mistake. But here's what the evidence, remember we get the benefit of every inference. Here's what they said they were going to do. Need to flesh out how Cathy could do this. Transition is funded. Transition, by the way, not stop immediately, transition. Showing help homeless and save face in the transaction from funding task force. You know what they probably told him to do if it turns out he gave the 100 is give a little bit more and then come on over. And that's the inference, and you just can't get away from it on this evidence. They patted each other on the back over it.
just wanted to respond to that. The email that he's referring to was from a September 27, I think it was 27, September 2007 meeting that Mr. Cathy was not in attendance. No evidence that he even knew about this saving face comment. And it is wildly speculative to assume that Mr. Cathy stopped funding the task force or donated $100,000 in July of 2008 because he was saving face. There's no evidence that Mr. Cathy said that, and summary judgment cannot be denied based on speculative evidence.
There's Mr. Cathy's testimony on what caused him to not give.
Yes, sir.
I'll be as brief as I possibly can, Your Honor. My name is Jason Hergenrother, and I'm here on behalf of Emmanuel Fialco. I have one issue to discuss, that is the special master's finding that Mr. Fialco is liable for wrongful foreclosure. So I'm not accused of making false statements. I will quote directly from the special master's order. The special master finds, among other things, that ICFIS was formed for the purpose of purchasing the promissory notes on the property. The special master finds that ICFIS has two trustees, Valerie McClellan and BCIC. Special master further finds that Ms. McClellan is ICFIS's sole officer and director and is the sole manager of BCIC. Special Master further finds in his order that Ichthus purchased the task force's notes from Ice and Mercy for a sum of about $781,000. Special Master further finds that Ichthus borrowed the money to buy the notes from PFS. Special Master further finds that Ichthus advertised the foreclosure of the property, and it was sold in the courthouse steps on May 4th of 2010. Special Master finally finds that Ichthus was the sole bidder at the foreclosure, bid about $781,000, the amount it paid to acquire the notes from Ice and Mercy. Those are from the Special Master's order. Those are not incorrect statements of fact. From those, we can make very reasonable assumptions that Mr. Fialco did not purchase the notes because he is not a member of the company that did Ichthus. He did not foreclose on the property because he is not a member of the company that did Ichthus. He has never claimed any right or interest from a prior order. It was January 26, 2012. This court entered an order that said that Mr. Fialco has never claimed any interest in the property, has never made any statements that he has an interest in the property. That is still true to this day, and that's from a prior order of this court, also not a misstatement of fact. So I do not understand if the legal standard in order to be liable for a claim for wrongful foreclosure is that you must establish the legal duty owed to the foreclosed party by the foreclosing party, how Mr. Fialco can be deemed the foreclosing party when the Special Master found that Ichthus foreclosed on the property and that Mr. Fialco is not a trustee, a member, officer, director, or otherwise associated with Ichthus.
What's your response to that, Mr. Hall?
Your Honor, they've mistreated the Special Master's order. Nobody doubts that Mr. Fialco set up these entities, a Nevada trust. Nobody doubts that it's not registered in Nevada. Nobody doubts that he set up these entities and actually went through the motions of setting them up. Nobody doubts that. That's all the Special Master's background stuff says. What the Special Master found, though, was that there are real material questions of fact as to whether any of these were real entities and were real issues. If the court goes later on, and I was trying to grab it while we were talking, if the court goes later on in the Special Master's order, you will find that the rub of what he says is that there are real questions as to whether this is an entire fraudulent relationship and a scheme. One of them comes from the note that is at one point in time $900,000, another $980,000, another $780,000. One of them comes from Mr. Falco's own email where he says, I want to stay in the background. I'm thinking of setting up these things. One of them comes from the fact where Mr. Fialco calls you a liar because you say your group had something to do with this when we got an email saying he's the one who transferred the money, and he didn't transfer it from Ichthus. He didn't transfer it from PFS. He transferred it from his wife's investment account. Now, so A, point number one, I don't believe any of these are real organizations, and I think they all get pierced through. Point number two, it doesn't matter. The law of Georgia is that if you join a conspiracy, you are liable for everything that conspiracy did. Mr. Fialco, there can be no question, is up to his eyeballs in this conspiracy. He's liable for it. It doesn't matter. It doesn't matter. Now, I will also tell you this. Number three, Mr. Fialco is also liable for his own deeds. He doesn't get to say, oh, I was working on behalf of a corporation, which he says sometimes. Sometimes he says I was working on behalf of Ichthus. Sometimes he says I had nothing to do with Ichthus. But he's the one who made the fraudulent statements. He's the one who participated in these efforts to kill the funding. He doesn't get away from those just because he's formed some corporations. Heck, if we did that, every criminal in the world would form a corporation, go out and rob a bank, and then say, I'm not responsible, I was working for the corporation. That's not how it works. So that's how I would respond to that. The rest of their arguments, I think, have been dealt with pretty carefully in the brief, Your Honor.
All right, let's break till 1:20, please.
Thank you.
Remain seated. Court come to order.
All right, please be seated. All right, let's take up the dispossessory portion.
Your Honor?
Yes.
Just before we get started, Lynn Robertson, I'm here on behalf of Atlanta Downtown Improvement District. I think Mr. Hall earlier indicated that he would rely on briefs on our motion to dismiss based on immunity. I would advise the court to just on the briefs that have been submitted.
Thank you, good to see you.
And if I may be excused
You may.
early in case I need to leave. Thank
You may.
And actually, Your Honor, I was actually referring to our motion. We had an objection to the special master's order. I was not actually referring to Ms. Roberson's motion. However, I'll defer to Bob, and if he wants to leave it on to the briefs, that would be.
That would be fine with me. The only thing I would add, Your Honor, is that we were aware of the ADID's objection to the October special master's findings. He withdrew those and submitted another ruling on December 13th. I'm not aware of any objection to the December 13th ruling.
I don't know if we filed them, but we'll go through it and see if we have objections to the extent he didn't make any changes to what we had previously objected to.
Thank you, good to see you.
That would be a little late, but okay.
All right, you're excused. Thank you.
And then, Your Honor, if I may, I would like to take up the issue of Mr. Levinson prior to his arguing in the dispossessory or appearing at the council statement.
All right, tell me about that, please.
Okay. Your Honor, this one to me befuddles me as well. This is about as clear as day to me. The canon, the judicial canon, prohibits judges from practicing law unless allowed by the law. The canon has a very particular portion that deals with part-time judges. It comes at the very end. It says a part-time judge is a judge who serves on a continuing or periodic basis, which I think is certainly Mr. Levinson, but is permitted by law to devote time to some other profession or occupation. And then it goes on to list what they cannot do. They should not practice law in the court on which they serve. He's the magistrate court, the state court. I agree that's not it. Or any court subject to the appellate jurisdiction of the court on which they serve. And I'm not sure if he falls within that or not. It's a little confusing, and one of my partners and I have argued about it. But the next one is dead clear. Or act as lawyers in proceedings in which they have served as judges or in any proceeding related thereto. I wrote to Mr. Levinson when Mr. Levinson made an appearance, I think, in the beginning of June. Honestly, I didn't know who he was. I got a conflict letter from him on June, I think, 30th, where he indicated that he was serving as, he had a conflict because he may be in the magistrate's court as a judge. I went, looked at his website. He professes to have done hundreds of thousands of these things. I went back and looked at our case, and he signed the order transferring the dispossessory and consolidating it here. It is not a qualitative analysis. It doesn't matter how involved he was. If he's been a judge in it, and there's no question he's been a judge in it, he signed it. He had, I mean, maybe he doesn't have in place procedures for conflict checks like this. I would hope that he does, doing the number of cases that he does. But regardless, now that it has come out.
There was a dispossessory filed, and
Yes,
this
sir.
case was filed at the same time.
Yes,
and
actually,
we decided to consolidate them here.
Correct. And then what happened is we brought down an order in the dispossessory case, transferring that case and consolidating it. So there can be no question that it's in this case. I mean, Judge Levinson's own order, his own order that he signed, specifically says, this case shall be transferred to the Superior Court of Fulton County and shall be consolidated with and become a part of the Superior Court action. So that is the case. This is the issue that he signed an order on. The rule is clear. He has to leave. Now, I wrote to him. I didn't want to bring a motion before you. I wrote to him. I pointed him to the order. I pointed him to the canon. He didn't respond to me at all for a week. I then wrote to him again by email. He said, I disagree. I said, well, can you tell me why? Because I didn't want to bring a motion if I was wrong. He declined to tell me any basis on which, he said, I would never try to convince, sort of tongue-in-cheek, a lawyer like you of anything. And I've put that into the motion. And he just simply refused to leave. So I had to bring this motion. I think it's completely improper, and I think the code is clear, and I would ask that he be removed and that all of his filings be struck as a violation of the judicial canon. Thank you.
Your response?
Yes, sir. Thank you. Judge, I have filed a response today. May I approach and
Sure.
give it to Your Honor? I had filed a response today to the motion to disqualify me. Let me walk Your Honor through. First, the gravamen of Mr. Hall's argument is that this is a related case. It is not a related case. The order that was submitted to me by consent was at a time in 2010 that Ichthus Community Trust versus Metro Atlanta Task Force for the Homeless and Anita L. Beatty had been filed as case number CV 185971. The client for whom I speak is PFS, who was not a party to that case, was not seeking any relief in that case, and didn't even have any litigation pending for or against PFS at that time. In 2010, apparently, and Mr. Hall is right, with the volume of cases, I don't do a conflicts check because it would be virtually impossible to know where to go to check for those kinds of things. But in 2010, apparently, when Ichthus sought to file a dispossessory against Metro, I just call them the task force, they had been served, no answer had been filed, and some proceeding had been before Your Honor that very day, and you and the parties must have agreed for that case, the magistrate court case, to be consolidated with 185971. Subsequently, in civil action file number 2010 CV 187740, a subsequently filed case, Metro, the task force, filed suit against Mr. Fialco and a variety of other defendants I won't name, including Preferred Funding Solutions LLC, which is we use the acronym PFS. So the action that the parties consented to and that I perfunctorily signed an order on, I'm not denying that. There's no question, Mr. Hall's right, that was presented with a myriad of other consent documents to me before, in a matter I had not heard, there had been no scheduled hearings on, and I not ruled on. But nonetheless, and I understand Mr. Hall's argument that that case, where Ichthus is no longer the owner of the property, Ichthus having deeded the property, I believe in lieu of foreclosure, though I'm not entirely sure, to PFS on or about February 2011. PFS then had standing to bring, now as a defendant in 187740, a claim for dispossession. Now, I'm not certain I understand the history of the decisions to allow or disallow PFS to file a dispossession, but I believe that ultimately there was an order that said, do nothing further, I'm paraphrasing, until this court allows a dispossessory to go forward. And that is what your board the other day scheduled for today, to make a determination as to whether PFS should be allowed to file a dispossessory, which has not yet been filed. I want to say that again for emphasis. That dispossessory by PFS has not yet been filed because you have not allowed it to be filed. The hearing today is to determine whether PFS should be allowed to file a dispossessory in this court.
Can that issue be decided on the briefs, Mr. Hall, as to whether or not they should be allowed to file?
The issue of whether they should be allowed to file a dispossessory?
Yes.
Your Honor, I would like to have oral argument on that issue. I think that's an incredibly important issue, and that's the biggest issue that we're going to deal with.
Well, I mean, I understand both sides of this argument about Judge Levinson. His pleadings have been You represent PFS?
And, well, I'm co-counsel with Mr. Robbins. I mean, Mr. Robbins has signed on to the very pleadings which Mr. Hall seeks to be struck. So, well, you know, understandably, I understand Mr. Hall's argument that they should be struck, but Mr. Robbins is also counsel for PFS and has signed the exact same pleading which he seeks to have struck.
I don't think the pleading should be struck if Mr. Robbins has signed on too.
He signed on after I filed my motion to disqualify, and after I sent my letter. It was a last ditch, it was a last minute effort to jump on board and say, me too, was what it was. But, you know, the court can consider certainly anything that it wants, but PFS is owned 60 or 65% by Mr. Fialco's wife. This is the same case that we're in. The fact that we have not filed a new dispossessory has nothing to do with anything. This case, Judge Levinson signed the order transferring the case and consolidating it. He cannot, in good conscience, argue that appearing here in the case that is consolidated with the one he signed an order on is somehow different. And I'll tell you, it's very important to my clients because they feel like there has been an effort by these defendants to peddle influence everywhere. They feel that is what is going on. It is incredibly important. I cannot for the life of me understand why once a judge confronted with a straight judicial canon would come up and say what's being said here. I mean, it's just completely untrue. It is the same case, it's the same parties, and in fact, when they transferred, when ICFIS did this backhanded transfer of the title to the property to PFS, it was in violation of your order that said they couldn't even transfer it. Judge, I just don't think there's any question about this, and Mr. Levinson needs to go, and quite frankly, I think he knows he needs to go.
May I finish my response, Judge?
You may.
Thank you. In the order that Mr. Hall refers to, the consent order, it refers to the parties being the certain litigation, Superior Court of Fulton County, civil action file number 2010, CV 185971. That is the case that was presumably in place at the time, ICFIS versus Metro. That's the only reference in this order to whatever pending or related cases were involved. Subsequently, I'm assuming, and I don't know, subsequently, a new action must have been filed by Metro, and I defer to Mr. Hall, I don't know the timing of those things. That's the action that was the suit against my client now.
Well, I need to make a decision on whether or not you can participate.
Yes, sir. But for the purpose of today, Mr. Robbins can certainly ably address that, and if Your Honor decides to disqualify me, then it would not affect.
All right, I'm going to take that under advisement, and I'm going to ask Mr. Robbins to put forth your argument. Is that a temporary stopgap measure, Mr. Hall, that'll work?
Yes, sir, Your Honor, thank you.
Okay, but I don't have enough to make a decision on that. Okay. All right, please proceed, Mr. Robbins.
Yes, sir. I'm not a judge, I've been part-time. Too many courtrooms as it is. May it please the court, my name is Richard Robbins, representing Premium Funding Solutions, and what we are here on per your prior court order is Defendant Premium Funding Solution LLC's request for reconsideration of its petition for leave to file dispossessory action. That was a request that we had filed over a year ago on April 30th, 2013. Your Honor, it has been 3.5 years since PFS has acquired title and is a recorded title owner. Did you need to?
No, we're okay.
Okay.
Please proceed.
3.5 years since PFS acquired title, and 3.5 years of not being able to exercise any ownership rights, or even to pursue its absolute rights under the dispossessory statutes. all that we have heard thus far on summary judgment is, as a matter of law, irrelevant to the issue of our right to pursue dispossessory. And that is a fundamental point. Whatever Your Honor holds on summary judgment, that doesn't matter in terms of our right to pursue dispossessory. As the cases, and I will just give you an overview of them today, many are in our brief, the issues of title, the quiet title, issues of wrongful foreclosure under consistent and well-established Georgia law is not a bar to a dispossessory action, even under circumstances such as that presented here. I want to make it clear, we are not here on dispossessory today. We are not here requesting eviction. We are not here requesting rent. We are not here to evict anybody today. All we are here for is a very simple order, which can be a one-sentence order, which is an order permitting us to pursue the rights we have under the dispossessory statutes. That is a right given to every property owner and every landlord in the state of Georgia against any tenant in default or alleged default, or against, like here, a tenant at sufferance, somebody who is occupying property without a lease. We have rights and obligations under those statutes. Task Force has rights and obligations under those statutes, and this court has obligations under those statutes. I appreciate very much that Your Honor felt, let's just put off the dispossessory until we have the trial, since we were, I think, a month away at one point. I appreciate that, then we don't have to get into these issues. We all know we are no longer looking at a trial, and certainly not one in the near future. This case is going to end up on appeal. It could be 1 year, it could be 2 years, it could be 3 years. And all of that deprives us of what we're entitled to. So any further delay is intolerable and, in my opinion, unconstitutional as a deprivation of our property rights. Your Honor has already recognized twice the right to dispossessory. October 17th, 2011, you issued an order of dispossessory. But you then withdrew that order because there was a pending motion for recusal, and you felt that you had to honor the procedural requirements and withdraw that order. But Your Honor already felt 3 years ago that dispossessory was appropriate, correctly so. Again, February 9th, 2012, Your Honor again granted dispossessory. However, we did not follow the dispossessory statutes, and the Court of Appeals reversed. And I think it is very important to read what the Court of Appeals said. They never suggested that dispossessory was inappropriate in any manner under the facts of this case or under the law. What they said was the exclusive method whereby a landlord may evict a tenant is through a properly instituted dispossessory action filed pursuant to OCGA section mark 44-7-50 et sec. The statutory procedures for dispossessing a tenant must be strictly construed and observed. And that means observed by all of us. Your Honor, we as owner, they as tenant. And that is all we are asking for, is a right to proceed under the dispossessory statutes as they exist in this state. Now, I first want to highlight the statute, which is a very straightforward procedure, and then discuss a few of the just mention a few of the leading cases to show you how crystal clear it is in Georgia what is the process and what can be asserted as a bar and what cannot be. The statute itself is not a permissive statute. It's a mandatory statute, as I will go through. And it is not just mandatory, it is an expedited statute. And the reason it is expedited is to facilitate the orderly treatment of property. So it is a very expedited process that goes on every day of the week nearby in magistrate court and on occasion in this court. If I might, Your Honor, just give you this. And it's 5 statutes. (44-7-50). It applies in all cases where lands or tenements are held and occupied by any tenant at will or sufferance, whether under contract of rent or not. So it applies here. You have a tenant at sufferance, there is no written lease. If the tenant makes a demand, which we have multiple times, excuse me, if the landlord makes a demand for possession and the tenant refuses, it says that the owner may immediately go before the judge of the Superior Court and other courts as well. But we have the right to go into court immediately. Next page, 44-7-51. When we submit the affidavit, and again, this is a printed form in magistrate court. Happens 200, if you ever go there, there's 200 people waiting there at a time. When the affidavit is provided, the judge shall grant and issue a summons. Not may, not after considering the equities in the case or fairness, shall grant and issue a summons. In B, the summons served on the defendant shall command and require the tenant to answer, and within 7 days. It is all highly, highly expedited. 44-7-53. Now, what happens if the tenant does answer and make defenses, make counterclaims, as they have every right to do? A trial of the issues shall be had. And then the statute says every effort shall be made, should be made to expedite a trial of the issue. Again, an expedited procedure. Now this is the crux of the situation that we are facing and what we have been deprived of. The defendant shall be allowed to remain in possession of the premises pending the final outcome of the litigation, provided, however, that at the time of his answer, the tenant must pay rent into the registry. Must, not discretionary. They must pay rent. 44-7-54, payment of rent into court. In any case where the issue of the right of possession cannot be finally determined within 2 weeks, only 2 weeks from the date of service of the summons, the tenant shall be required to pay into the registry of the trial court all rent and utility payments. If the tenant should fail to make any payment as it becomes due, the court shall issue a rent of possession and the landlord shall be placed in full possession. I emphasize the mandatory and not discretionary nature of the landlord-tenant statutes. And finally, none of this is stopped on appeal, Your Honor. If you look at 44-7-56, if a tenant loses, a tenant has 7 days, not the usual 30, but 7 days to file an appeal. Now, what does it say happens on appeal? Unlike a stay or a supersedious, like in most civil cases, the statute says the tenant shall be required to pay into the registry of the court all sums found as due, and the tenant shall also be required to pay all future rent as it becomes due. In other words, the statutory scheme is very simple, very straightforward, and is very mandatory. And the purpose of this is like the wrongful foreclosure policy, which is you have to tender the amount, is you can't get something for nothing. If you want to stay on the premises, you gotta pay. Now, you may have claims, and those claims will be heard, and those defenses may be heard, but you can't stay in some place without paying. And that's what the dispossessory statute says. They have the right to bring whatever defenses they want. They have the right to bring counterclaims. They even have the right, under the law, to pursue a separate action, as they have here for quiet title or wrongful foreclosure. But those are not, and I repeat, they are not a bar to dispossessory proceedings. I will just highlight a few cases because I think it is critical to see how clearly it has been decided by the appellate courts of this state. most of these are cited in our brief, but as you will see, they deal with multiple variations on the scenario, including those argued by the task force here. In Howard versus GMAC Mortgage, the Court of Appeals held just last year, 2013, alleged invalidity of foreclosure sale was not a defense to landowner's petition for writ of possession. I have it highlighted on page 3. The trial court did not err in granting the writ of possession, despite Howard's allegation that GMAC, the lender, had wrongfully foreclosed on the property. I could not be more straightforward. Now, they can bring that defense.
You made yourself quite clear to the court.
Okay.
Mr. Hall, let me hear your response, please.
Yes, sir, Your Honor. Your Honor, regrettably, this is an effort to lead the court down the primrose path once again. And it's based on inaccurate and wrong citations to authority. And I'll tell you why they lose this matter. They lose it because the law says they lose it. They lose it because logic says they lose it. And they lose it because of the harm that they're seeking to accomplish. Now, when we've been going through this issue, and Mr. Robbins has belittled my argument many, many times, and the underlying situation that makes this different from most cases that happen every single day is that the special master has already found in this case that there is a clear question as to ownership of the building, a material question of fact as to ownership. And I'll start from here because this is where I typically start when I start researching. This is Georgia Landlord-Tenant Law. It's by William Dawkins. If anything, it is the Bible of Landlord-Tenant Law. Here's the first section that he says with respect to this exact situation, and then I'll quote from you the cases. In certain cases, a tenant may have a dispossessory proceeding enjoined. If, for example, the basic dispute between the landlord and tenant is one of ownership, injunctive relief may lie if the proceeding is in magistrate court, which is where this one was, or state court, since superior courts have exclusive jurisdiction in cases regarding title to land. That's what the leading author has said. Now, what does he base that on? Supreme Court. I have cited this to Mr. Robbins. He did not disclose it to you when he came to talk to you. The Georgia Supreme Court addressed an almost identical issue in Carswell versus Scott, 255 Georgia, 798 at page 799. The only difference in that case was that I believe it was a piece of real property that didn't have a building on it, and what the argument from the person that foreclosed is you keep trespassing on the property. So they filed a motion to prevent him from trespassing any further on the property because they said you've been foreclosed. Here's what the Supreme Court said. The superior courts have exclusive jurisdiction in cases respecting title to land and equity, cites to the Constitution. The basic dispute between the parties is title to the property on which the trespass was alleged to have been committed. The appellant seeks a decree of title and affirmative equitable relief which cannot be granted in the civil court of Fulton County. They had brought it in the equivalent, essentially, of the state court. The civil court action should have been enjoined and the actions consolidated for trial in a court having jurisdiction of the claims of both parties. It was error to dissolve. He's asking you to dissolve just the injunction that you put in place, which incidentally they consented to in the beginning on that very first day. Not only did these guys come to the party knowing that they were going to be jumping into a legal battle, they consented to the injunction that we're traveling under, and they consented to us not paying rent. It's in your June 17th, 2010 order. The reason they did it is they wanted to curry favor. And now they want to change their position because it's become more expedient for them. Well, the law doesn't allow it. The Supreme Court said, error to dissolve the order restraining prosecution of the civil court action by the appellee. There is no question here that the core issue in this dispute is who should own this property. if you were to go forward and allow them to file a dispossessory action, if they filed it in this court, quite frankly, I think if they tried to file it now, there's an argument to be made that it would be an illegal filing because there's already a case that has a dispossessory here. But they're going to say we've jostled around parties, so that doesn't count. It would be error to allow them to go forward. The next Georgia Supreme Court case, Carswell versus, Norman versus Wofford. Here's what the Supreme Court said again in 1980. Under the allegations of both of the complaints, it appears that the claims arise out of the same factual setting. Therefore, it is error for the trial to refuse to enjoin the proceedings in the state court so that the issues presented by these facts may be tried together. Now, I've cited to other cases, Your Honor. I don't want to belabor it. I know that your time is short. So let me cite to one more case from the Georgia Court of Appeals, because they've told us exactly what you do when this situation comes, and I think you'll see it's exactly what we did. So you're confronted with an overall dispute that has to be heard in front of you. Somebody tries to get the jump and sneak this into a state court action where nobody gets to hear the bad acts. I mean, their whole argument here is you can't address issues of title. So what they want is to get this into a court where the only thing that's heard is there rent or is there not rent been paid? Because they want to keep the bad acts that I showed you earlier on from you. So here's what the Court of Appeals instructs everybody to do. As stated by the Superior Court, and this is Ransom versus Waldrop, 152 Georgia App 711, previously been cited to PFS. As stated by the Superior Court, the proper procedure would have been that in the event the plaintiff here, defendant in the state court as we would be, decided to seek an equitable decree of specific performance as well as a suit for damages, she should have sought to stay the action of the state court and to consolidate both cases in the Superior Court having jurisdiction of the claims.
So your position is quite the opposite of Mr. Robbins.
Yes, he's completely wrong. Now, let me move.
Go ahead.
If I may, let's talk about the logic of this, Your Honor, just for a second. Let's say we have his dispossessory, and he gets in there and he successfully convinces whatever judge this goes to that you can't hear anything but whether or not the task force paid rent. Okay? Well, what's going to happen then if that's what he convinces the judge? Well, the task force hasn't paid rent. We don't get to argue that the reason we can't pay rent is because...
I know what's going to happen. You're going to come to me and ask me to stay the dispossessory.
Of course I am. But
how's this case ever going to get tried?
Your Honor, it's very simple. Let's just set it down for a trial. We're ready to go. I have never asked for a continuance in this case, Your Honor. I've been ready the whole time. The last time this came up, I said, Your Honor, they want a continuance. I'm not going to fight them as long as I don't have to fight through this whole dispossessory nonsense yet again. But this is a tactical maneuver. And then look what happens. And it really is a devastating tactical maneuver because if they get their dispo, we get thrown out because we can't pay the rent. We get thrown out. They turn around, they sell that building to a BFP because now they've cleared their title. They sell it to a BFP. The building's gone. We've lost grandfather status. That's a homeless shelter. We've lost 3 homeless shelters in the city of Atlanta. I got 650 to 1,000 people out on the streets dying.
Well, depending on however I rule regardless about the dispossessory, how are we ever going to get ready to go to trial? Somebody's going to want to appeal those rulings.
Your Honor, there's nothing here to be appealed. There's a summary judgment order.
What is y'all's response to that?
On what?
Anything.
Well, Your Honor.
Yeah, go ahead.
The only reason it sounds like a law is in conflict is because it's misstated. Read, I commend to you the Bible, the Dawkins, and what that deals with is jurisdiction, and it's just wrong for him to say otherwise. What it says is, if, for example...
I have an opinion about what the law is on the dispossessory. All right. Now,
okay. Your Honor,
how can we try
if there's an equity argument as here, all those cases say, including the Carswell cases, it has to be in Superior Court. It can't be in state or magistrate, which has no equity jurisdiction. How is the case going to be tried? The first thing is we ought to be given our right to dispo, because we have a right to...
And I'll have a ruling in 2 weeks, about 2 weeks from today, on everything that's been before me today.
And they can assert it. Your Honor can follow the law on this as to their answers and defenses, and can order rent like every other claimant in the state of Georgia who has claimed wrongful foreclosure.
All right, y'all will have a ruling within 2 weeks from today. When can we go to trial after that?
Your Honor, we are ready, and we are ready to go at any time. I don't believe there is any issue, other than if you grant the dispo, I don't believe there's any issue that is appealable as a matter of right for the defendants. This has just been a summary judgment response, and the way to handle this thing is if we want to avoid error in this case, let's get this case in front of a jury. Let's not play games with
Well,
evidence.
I think that we have to figure out whether or not they have a right to file the dispossessory.
Correct.
I think that's front and center and must be decided, one way or the other.
I believe.
Special Master Strickland has ruled correctly, I believe, Your Honor. It is in line with the pundits, and you can cite to a million cases, but I guarantee you there's not a single one of those cases.
All right, well, you get a ruling in 2 weeks. I appreciate y'all's courtesies and professionalism. Thank you.
Thank you, Your Honor.